Under the Belgian Code of Economic Law, a line of computer code is legally assimilated to a literary work. It is granted protection not because it is a tool, but because it is viewed as an intellectual creation unique to its author. This legal status is rooted in European directives. As highlighted here in point 6, these rules establish a standardized framework for respecting intellectual property across all member states. Within this framework, software development is given its own dedicated section of the law, Title 6, providing a specific set of rules for computer programs that distinguish them from other creative works. This protection applies specifically to the form of the code and its internal architecture. If the structure reflects the author's own intellectual choices, it is legally shielded from unauthorized reproduction. However, there is a strict boundary. Copyright protects the expression of the code, but it never extends to the underlying ideas, the mathematical algorithms, or the program's basic functionality. This exclusion exists to ensure that basic principles and logic remain in the public domain, preventing a single entity from monopolizing the building blocks of technical progress. Therefore, software is protected based on the unique way it is written and structured, regardless of the specific task the program actually performs. Databases fall under a separate legal category, governed by a unique mechanism designed to protect both the structure and the vast financial investment required to build them. This system relies on a two-tiered layer of protection. Traditional copyright applies only to the structural arrangement, the original way the author chooses to select and organize the data categories. Beyond that, a sui generis right protects the content itself, preventing competitors from extracting the raw data if the creator can prove a substantial investment was made to obtain and verify it. Websites represent a third, more complex profile, as they are legally treated as a collection of separable parts. A website is not viewed as a single, indivisible work. Instead, the law decomposes it into its constituent elements. The visual interface, the written text, the graphic layout, and the underlying code are each evaluated as independent copyrighted works. This means a single digital product is often a layered architecture of different legal rights, each tied to a specific component and its respective author. While the civil definition of an author has remained stable, the tax code's treatment of digital creators has shifted significantly over the last few years. The central issue is the 15% withholding tax rate applied to income derived from the cession or concession of copyrights. Because this rate is substantially lower than the standard progressive tax on professional income, it became a primary method for compensating workers in the software sector. That changed in late 2022. The government revised the tax code and explicitly excluded software and IT-related creations from this favorable regime. This exclusion was challenged in the Constitutional Court, but in 2024, the court validated the change, ruling that developers did not face the same financial instability as traditional artists. This created a direct contradiction. A developer's work was still an original creation under civil law, but the tax authority began treating it as a standard professional service. However, the latest government coalition has moved to resolve this disparity, recognizing that software development is legally identical to other literary works. A new legislative project reintegrates computer programs into the copyright tax regime, with the change scheduled to take effect on January 1, 2026. This shift allows the IT sector to once again apply the 15% rate to creative income, though the requirements for documenting that creativity have become significantly more rigorous. For 2026, the focus of tax audits will be on the distinction between original architectural design and purely technical or maintenance-oriented tasks. To manage this risk, creators often seek a ruling, a formal, advance decision from the tax administration that confirms their specific work qualifies for the regime. Organizations must also implement detailed timesheets, providing a clear audit trail that separates hours spent on original development from standard coding or debugging. Because these regulations are subject to further legislative changes and administrative interpretation, the information in this video should be treated as a general guide rather than formal legal advice. The 15% tax rate is returning to the IT sector, but to maintain it, developers must be prepared to demonstrate the specific creative choices that make their code original.